Welcome to the Deal Calendar. I'm Mary Kathleen Flynn. The Deal Calendar is our new video blog that will be updating every Friday. It will give you a preview of events to come in deal making. The week of May 5th has a lot going on, including trials, deadlines, and earnings announcements. On Monday, May 5th, the New York trial and the dispute between Clear Channel Communications and its private equity buyers Bain Capital and Thomas H. Lee was due to start. It's been delayed, but will likely begin during the week. We'll have more on that in a moment. On Tuesday, May 6th, there's the European Union's provisional deadline on the proposed leverage buyout of Getty Images by Hellman and Friedman. On Wednesday, May 7th, quarterly earnings are due from News Corp, a bidder for Newsday. And on Thursday, May 8th, Takeda Pharmaceuticals' tender offer for Millennium Pharmaceuticals is due to expire. With me now to take a closer look at the Clear Channel dispute is Scott Stewart from The Deal. The trial got delayed. Is it likely to start this week anyway?
Yeah, the delay is really a matter of the judge's schedule. There was another trial in the way. It will likely begin this week.
And just set the stage for us a little bit. What's the significance of this dispute?
Okay, it's the Bain Capital T.H. Lee buyout of Clear Channel, $26 billion. The plaintiff sponsors are seeking enforcement of the debt commitment letter with banks led by Citi and Deutsche Bank for the $21 billion in funding for the deal. The plaintiffs claim that based on arguments they've already made in summary judgment, et cetera, the plaintiffs claim that the banks have been proposing conditions that are absolutely unacceptable and as a way to get out of the funding and the loss they will take from funding. And the banks alternatively argue that the debt commitment letter doesn't terminate until June 12th, and they have been in a negotiation and they haven't violated the contract.
There are a lot of different things going on in this case, right? There's more than one trial. If the audience had to pick a single thing to be looking for at this stage of the game, what would you ask them to focus on?
Well, so far the banks have not won at any turn with their legal arguments. They've attempted to change venue. They've attempted to disarm the Texas litigation, which is a separate suit by Clear Channel and one of the sponsor entities seeking, claiming tortious interference with the merger agreement and seeking sizable damages. And we're talking about billions and billions of dollars in a venue in Texas, jury trial that you don't want to be in if you're a large corporate defendant. It's probably the last place you want to be. We've seen the banks fail so far in many of their motions. They haven't been able to squelch the Texas trial, which is really the leverage that the sponsors have, the fear of considerable loss. In New York, with the New York litigation, we're looking to see what the judge decides. We're also looking to see what information the sponsors can produce that show what thinking the banks were doing in December, in January, prior to March 27th. That really shows that they were trying to get out of the deal, that it wasn't a fair negotiation.
How much longer do you figure this will drag out?
Well, the deal and the debt commitment terminate June 12th. Everybody's cognizant of those dates. The Texas litigation won't begin until June. The trial in New York could easily last a week, perhaps longer. We don't know when the judge will decide. We also don't know if the banks might settle. They've already offered to settle through a binding arbitration, which was denied. Sponsors thought that they weren't really offering anything new, that it was just another way to offer what was unacceptable. But things haven't gotten better for the banks, except that the debt market, the loan market is improving. Banks have reshuffled their balance sheets a little bit, offloaded some syndicated loans. So the loan market's up a few points. They're in a better place in terms of funding now, in terms of the loss they'll take, at least a little better, incrementally, than they were a few months ago. So if it's just a delay tactic, it's been somewhat successful. So we're looking for, obviously, what comes out at trial, and who knows, we might see a settlement before something embarrassing happens.
All right, well, it sounds like it may wrap up quickly.
It's possible. I wouldn't hold your breath.
Okay, I won't count on it. Thank you, Scott Stewart, and thank you for watching the Deal Calendar. Come back next Friday when we'll have another update for you. And in the meantime, if you have any suggestions for our work in progress, the Deal Calendar, please send us email at reporters@thedeal.com. I'm Mary Kathleen Flynn.